on our agenda for this morning, and that is LD 923, an act to enact the Stop Guilt by Accusation Act. And I would welcome the bill's sponsor, Representative Sampson, to the Judiciary Committee to present LD 923 for us today. Welcome, Representative Sampson, and good morning.
Thank you, Mr. Chair. Good morning. Nice to see you. Senator Carney, Representative Harnett, and members of the Committee on Judiciary. I am Heidi Sampson, representing the good people of House District 21, Alfred, Limerick, Shapley, Newfield, and Parsonsfield. I'm here to present LD 923, an act to stop guilt by accusation. Allow me to present you with an illustration to why I believe this bill is necessary. Please consider criminal justice reform. For example, consider a young adult a minority male who is accused of a heinous crime. This issue receives lots of news coverage. After all, it's juicy, salacious, newsworthy story. Obviously, the media has every right to cover the story as they see fit. If, however, this young man is acquitted, the story doesn't rise to the same newsworthy level for whatever reason, and the media fails to report it. This is actually quite dishonest and falls in the realm of the sin of omission. Without any intervention, this individual is now stigmatized for life and left to his own devices to explain away the cloud of suspicion. This has now destroyed his reputation, character, and dignity. He's continually faced with a cloud of suspicion which can prevent him from getting a job. He faces the real possibility of being an outcast in his society, permanently stigmatized, avoided, and shunned. This bill would allow him to submit an affidavit within 20 days of being acquitted to the representative media outlets who covered the story originally. In turn, these outlets will have 10 days to report in the same manner the time, place, and scale and magnitude of the original reporting. If a media outlet does not follow up in a timely manner, the victim can file a lawsuit in civil court against that media outlet to seek damages. This bill will allow the media to demonstrate integrity and honesty in their reporting. Out of respect for a human being's future, they should tell, quote, the rest of the story, end quote. In turn, this will restore the media to its original intent, a watchdog for the people. It will also stem the erosion of fundamental civil liberties when individuals are cast in a false light, which has resulted in destroying lives. I thank you for your consideration to this matter, and if we as people are concerned about justice, this is a vital piece. Thank you.
Thank you very much, Representative Sampson, for bringing the bill forward to the Judiciary Committee today. Are there questions from committee members for the bill's sponsor, Representative Sampson? Seeing none, again, thank you very much for bringing the bill. Representative Thorne.
Thank you, Mr. Chair. Sorry about that. I was trying to do some research because I just saw something along the lines of this yesterday on the news where they showed an individual who was involved in the Capitol siege. And they showed video of him and said he was performing acts of violence and then left the story alone. So it was kind of like, you know, they already went over that and found him guilty and showed you that right on TV and went on to the next story. So thank you, Representative Sampson, for bringing this forward. And I'm sure that there are many cases that would illustrate this. My one question is, when you present this going forward, is there opposition that you've encountered contrary to these that are outlined?
Well, I have, this was one of the bills that was submitted early on, and the media picked up on it and did a story basically taking some things out of context that I had stated. However, they dismissed this as being unconstitutional. And I would like to have that challenged. And apparently there's someone that has submitted, the Maine Press Association has also submitted testimony against this. However, I think this is an issue that deserves to be explored a little bit deeper.
Follow-up question, if I may, Mr. Chair?
Yes, Representative Thorne, go ahead.
Thank you. As far as First Amendment rights are concerned, and I don't think that I've ever encountered a situation where it's almost like forced First Amendment rights, where you're requiring somebody to speak on the opposite of what they've reported. And I didn't know if that came into play or you encountered any involvement around that issue.
Well, I think that was a discussion that I had with an individual in the media. But I think, it goes back to sort of the moral obligation. And that seems to have been eroded. And it's terrible to have to legislate morality, but to a great extent, that's what's happening on so many levels. And I don't understand why we spend time talking about all this social justice, these social justice issues, and yet here's an issue. I give you an example, and this is happening all over the country and in Maine. So here's an example where the media is actually complicit in an individual's life and the demise of their future. So where's the justice in that? So I would really appreciate this committee digging into this a little bit more and kind of examining it from more directions, and not be subject to listening to certain pressures. Let's look at all sides here and the issues that you all deal with in this committee on justice. Where does this fall into place? And is this relevant? And I would urge you all to really explore this.
Thank you for that, Representative Sampson. Thank you, Mr. Chair.
Thank you.
Thank you, Representative Thorne, and thank you for your answer, Representative Sampson. Are there additional questions from committee members for the bill sponsor, Representative Sampson? Seeing none, thank you very much, Representative, for bringing LD 923 forward to the Judiciary Committee this morning. You are welcome to stay as a panelist if you would like for the remainder of the public hearing.
I appreciate it. Thank you, sir.
You're very welcome. I will now turn to persons who have registered to testify in support of LD 923. And I will next recognize, and I hope I get your last name right, sir, Christopher Sevier, Esquire.
Yes, Mr. Chairman. Let's see. Can you guys see me? Yeah, here we go.
Well, we did, and then we lost you.
Let's see. Maybe there we go.
Now we can.
Yes, sir. Thank you, Mr. Chairman. Thank you so much, members of the committee, for having me here.
I should, just before you start,
yes, sir.
3-minute limit on testimony, and I'll let you know when we're running out of time.
As a lawyer, I'll try to get that in there. So I'm going to talk very quickly. Feel free to ask me any questions that you might have. So basically, I went to Vanderbilt undergrad, Vanderbilt Law School, constitutional federal litigator, here in support of this bill. Effectively, this is a bill that promotes truth in reporting. It does affect criminal justice reform, and it will do a lot to protect fundamental civil liberty interests. So basically what the bill says is it says going forward in the state of Maine, if a person is accused of a crime, if they're hauled before any kind of civil court or military tribunal, any kind of government body where they're accused of wrongdoing, if the plaintiff, the media has a fundamental right to report on the case in controversy pursuant to what's called the freedom of the press under the First Amendment. If the plaintiff or petitioner in the case end up getting less relief than they could have acquired or they were trying to get, and once the verdict is rendered, if the defendant in the action provides an affidavit to the media outlet within 20 days after the verdict is rendered, testifying to as what happened to the actual result in the case, the media outlet then has 10 days to do a follow-up publication in the same time, place, manner, and scale. And if they fail to do that, they can be subjected to a civil lawsuit where the plaintiff in the case could then seek $10,000 in statutory damages and attorney's fees. And so by way of an example to understand what this means in English, it would be if someone was accused of 50 felonies, let's say Representative Joe Snuffy was accused, it was a political hit job, someone falsely accused him of all this stuff, and the media reported on it and he was acquitted and he provided the affidavit. Let's say he was plastered on the front page of a publication. Well, the media should take reasonable steps to do a follow-up publication reporting on the outcome of that instead of burying it down on page 19 to where, the person is not really, the full story is not out there. The state has a compelling interest, a narrowly tailored compelling interest to not allow for what's called defamation in kind. This bill creates a new tort called that. The opposition, Representative Thorne raised a question about, is there opposition? The general opposition is that the bill in some general vague way offends the First Amendment. Self-serving entities float that argument. But the fact of the matter is that invasion of privacy, putting someone in a false light, and basically slandering them in a way by selective reporting is not protected under the First Amendment. The state has a further compelling state interest to enact this bill because it involves government institutions. We have a fundamental duty to protect the integrity of those institutions. Right now, there's really no accountability. There's no incentive to stop people who may disagree with each other for religious or political reasons to float and file false accusations against someone, knowing that the person's going to be acquitted. I'm sorry, I can't see that. The person's going to be acquitted, and but the media might not do a follow-up publication. And so in the instant case here, this would really help your constituents. It will very much protect fundamental rights. And Mr. Chairman, I'm not sure if I'm over my time, but that's a very fast overview.
You are. Thank you very much, Mr. Sevier. And I forgot to remind people when they begin their testimony, we need to know your place of residence for our records. Could you indicate where you reside?
So we're called de facto attorneys general. We're federal litigators that litigate throughout the country, including in the circuit that Maine is located in. So, we're working in 42 states right now, but when we're in Maine, we're in Augusta. That's what we would be based out of when we're there.
Where do you reside, sir?
New York City.
Thank you. And I would open this up for questions from the committee, and I recognize my co-chair, Representative Carney. Senator Carney.
Thank you, Representative Harnett. Mr. Sevier, what is the street address of your Augusta, Maine office?
Well, so again, that would be my colleagues are the ones that have the all that kind of information. But when we are there in Maine to litigate, because Maine is part of the constitutional republic.
I'm not asking for a long.
To be honest with you, ma'am,
the street address, please.
I appreciate that, but in the instant case, we don't really like to give out that public information. But I can send it to you through writing.
Are you authorized to practice law in the state of Maine?
I'm authorized to practice law in the state of Maine if I appear pro hoc vici in a federal case in controversy.
So
Point
you're
of
not
order,
admitted
Mr.
to
Chair.
practice law.
Point of order, please.
You're not a member of the.
Point of order.
Would you let the senator finish her question, sir, and I will get to your
May
point.
I ask a point of order before she continues?
Representative Thorne, you may proceed.
In my entire time here at the Judiciary Committee, this is the only time that I have ever seen a member of the Judiciary Committee badger someone about their address and where they reside and a street address. And I don't understand why.
As I indicated, I failed to ask the witness or Mr. Sevier where he resided. That was my fault. So I asked
But I
him.
understand that. I'm just making the point of order that there have been other witnesses that haven't stated where they live, nor have they provided a street address of where they reside. And I'm just wondering why this particular person that's given this testimony is being asked such specific questions.
I believe that he is identifying himself in his title as Christopher Sevier Esquire, which indicates he is an attorney. The Senator Carney was simply asking if he is registered, licensed as an attorney in the state of Maine. I consider that an appropriate question. And that's
No,
my ruling.
I beg to differ, Mr. Chair.
Maybe
She
you
didn't
can-
simply ask that. She went into specifically asking an address. And I've yet to see another person providing testimony that's been required to provide a specific address other than a town. And I just was wondering why.
He represented that he was here on behalf of an organization with a place of business in the state of Maine. The inquiry was to where that business was located. I've ruled on your point of order. I've overruled it. Senator Carney, you may continue.
Thank you, Mr. Chair.
You're welcome, sir.
I just wanted to clarify that Mr. Sevier is not, he is not a registered member of the Maine Bar.
Thank you, Senator Carney. Does that conclude your questioning?
It does. Thank you.
I mean, can I respond to that?
Well, the question's been asked and answered,
All
sir.
right, okay, sure.
Representative Babich.
Thank you, Mr. Chairman. Mr. Sevier, I'm looking at recourse here and trying to just make sure I understand what you're trying to achieve. I mean, I understand you did mention the term political hit job, and I do understand potential injustices that could happen. But regarding recourse, celebrities and public officials don't have the same slander and libel protection that normal folks do. But regarding slander and libel for the citizens that you're looking to protect here, if a member of the press writes something that is an editorial, I mean, even celebrities in Hollywood have been successful in going after the press for untrue accusations, which actually has surprised me. But there is a vehicle for that as far as factual corrections, or they wouldn't be corrections because they'd be a reporting of facts, but for a factual update. Is that what you're trying to achieve with this bill?
So in the essay case here, it's Representative Sampson's bill. I'm here to testify in support. What she is attempting to achieve, we would believe, would be several things. One would be, you talked about public figures, which were held to higher standards when it comes to defamation issues. So let me just first start by talking about the private individual, like your constituent, so to speak. Okay, so she gave an example of, let's say, like a 19-year-old African-American male is accused of rape, murder, mayhem, and the media finds it to be in their economic interest to report on the case in controversy. And let's say that individual is acquitted a year later, but the media just says, it's not in our interest to report on this. We have other things. Something else is happening right now, so we're not going to cover it. Well, that individual, that private citizen, when he tries to get a job, it might affect his personal life, his dating life. I mean, all aspects of his life, his fundamental civil liberties can be eroded and ruined by the selective reporting. It's important to note that the bill only involves cases and controversies where there's a government body who's overseeing some kind of accusation of wrongdoing. So, we want to protect the integrity of those government bodies and not have them be used where people will float false based on the ends justify the means or some kind of malicious reasons to float a false report in order to then the media come in to selective report and not give the full story. It does invade privacy. It does cast people in a false light. And so the bill's intent is to promote truth in reporting, to protect fundamental civil liberties liberty interest, and to protect the integrity of government institutions. Prosecutors right now have also a lot of times in the North and the South, in red states and blue states, a lot of times prosecutors will go after people because they disagree with their religious and political worldview, and knowing that they're going to file something and the media is going to report on it and they're going to get exonerated and there's no follow-up publication. We need to deter that kind of practice from happening. Like the prime sponsor of the bill said, this bill really will promote a lot of criminal justice reform in a very bipartisan manner that will promote human flourishing. And that's the ultimate goal. And I'm sorry to give such a long answer, but that's a...
No, if I may, Mr. Chair, I'm concerned about the bills trying to get at the motivation of what you're trying to correct, but it sounds like the bill is also requiring a process and a potential penalty for no wrongdoing. In other words, merely reporting the facts, you're saying is unfair if a person is accused, but then doesn't get the follow-up coverage on their acquittal. But as far as wrongdoing of reporting of the facts, that's not a requirement in order for this bill to be effective.
Selective reporting, respectfully submitted, selective reporting in a case in controversy where someone's been accused of something major is in and of itself a wrongful act. It's called defamation in kind. The bill can only be enforced, the statute can only be enforced if it's properly complied with. So let's say someone's accused of 50 felonies and they get acquitted and they don't provide the affidavit, it was reported on and they don't provide the affidavit in time. Well, they can't enforce this statute. But if someone is accused of wrongdoing, the media reports on it and they economically are benefiting off of that, they're profiteering off of the misery of someone else. And if they were acquitted and if they want the truth of the result published, they should have the fundamental right to go to the media outlet that's profiteering off of their misery and require them to do complete reporting. And failure to do that is self-evidently immoral. It's self-evidently wrong. It's certainly subversive to human flourishing. And it puts our integrity of our justice system in question because it allows for and incentivizes abusive process and malicious prosecution. It is a credible form. It turns the media outlets into slander machines is what it does. It's incredibly destructive. It erodes very real fundamental civil liberty interests.
Thank you, Representative Babich. Representative Libby, I said I would call on you next, and I didn't want you to have to keep your hand up all that time.
Thank you. I don't mind, but I do have a clarifying question to ask Mr. Xavier. I appreciate the point of order that Representative Thorne called. I think it was completely appropriate, and I would like a clarifying response from Mr. Xavier. I am brought to mind that we had a recent bill where we had out-of-state lobbyists advocating on behalf of it, and that bill passed out of our committee with a majority report ought to pass. And I did not hear a single question about a street address during that public hearing. So I would like to hear some clarifying comments from Mr. Xavier in his response to the point of order. Thank you.
So, as a lawyer, if I'm not getting beat up, I'm not doing something right. So I'm used to it. I'm not here to talk about me. I'm here to talk about the merits of the bill before you. Maine is part of a constitutional republic. We do litigate in federal district court, including the circuit that Maine is a part of. This bill does involve fundamental First Amendment federal issues as well as state constitutional issues as well. I'm coming to you by way as a member of the Article 3 branch to help provide clarity, if you guys want it, in terms of whether or not Representative Sampson's bill that she's the primary sponsor of, if it's enacted, will it survive judicial review? The question for you guys is to determine whether or not it would help your constituents and would benefit them by protecting their fundamental civil liberties. We do not give out our public address. We do go to Maine. We will be there for other bills. We have lots of bills in lots of states, and we love our partners in Maine. We partner with a lot of groups when fighting human trafficking, child advocacy centers, and so forth. But we really don't want to get off topic of other than, do you think this would help your constituents? Do you understand the merits of the bill? And I'm here to testify as to whether the bill would survive judicial review in federal district court if it was enacted. And the answer is yes, it would, because slander, basically putting someone in a false light, those are not protected forms of free speech. And so that's a quick answer. I basically just want to keep going back to the merits. And this is politics. We're supposed to gig someone. And I always take it as a compliment if someone gets off topic, because if they want to talk about me or something, then they can't defend. They don't have a very good argument to oppose the bill. I would respectfully submit. So I take it from that way. So
Thank you, Mr. Sevier. And I would appreciate an invitation for Mr. Sevier to the work session.
Thank you, Representative Libby. Representative Babbage, is your hand still up or is it residual?
I apologize, Mr. Chair. No, it is not.
It's okay. Thank you. Representative Thorne.
Thank you, Mr. Chair. Mr. Sevier, you mentioned politics. Does this disproportionately affect any political affiliation more than another in your experience?
To be honest with you, based off of our monitoring these kinds of situations dealing with malicious prosecution, I was a prosecutor for the military and for the federal government as well. Malicious prosecution is a serious problem. It can definitely cut both ways. If you have let's say a prosecutor that favors Republican Christian ideology, or you have a prosecutor that favors, LGBTQ leftist ideology, they might have incentives in some ways to bring false claims against someone that maybe have just kind of tenuous probable cause. There might be a very low reason why they can get away, justify bringing the case, knowing that the media is going to report on it and they can hurt that person's career. They can hurt their personal life. They can erode their fundamental liberties because there's no real form of accountability. Like one of the representatives said, is it wrong just to report on the facts? And the answer is yes, if they selectively report and if it involves a government entity. There's room for an enormous amount of abuse that cuts across party lines. And so basically, this isn't about Republican or Democrat. This is about right or wrong. And this is about protecting the integrity of our justice systems. It's about protecting people that can't defend themselves. I mean, if I'm not getting attacked in the media, I'm not doing something right. That's the way I feel about that. But there's a lot of people, and I can defend myself, but there's a lot of people who are like, back to the example that the representative gave, Representative Sampson, where she referred to some minor, some 19-year-old kid gets accused of something. The media reports on it. He's got no voice, and so this will really, protect them. So,
thank you, Mr. Sevier. I appreciate that answer, and thank you, Mr. Chair, for indulging my question. And we'll save the detailed ones for the workshop. Thank you.
Thank you very much, Representative Thorne. Are there other committee members with questions for Mr. Sevier? Seeing none, thank you very much for bringing your testimony to the Judiciary Committee today. We appreciate your attendance, sir.
Thank you, members. Thank you very much. Thank you so much.
That is all that I had signed up, registered in testifying in support of LD 923, but I do want to see if there are any members in the attendee room who are here to testify in support of LD 923, and if so, if you could please raise your electronic hand. And seeing none, I will now turn to those who registered to testify in opposition to LD 923. And I would first recognize Judith Meyer of the Maine Press Association. Welcome, Ms. Meyer, to the Judiciary Committee again. It's good to see you. And as soon as you are ready, begin your testimony. I will remind you that we are on a 3-minute clock today. Thank you.
Thank you, Senator Carney, Representative Harnett, and members of Judiciary. My name is Judy Meyer. I live in Auburn, and I'm a member of the Maine Press Association, here to testify in opposition to this bill. This bill seeks to legislate how news outlets cover police and court news. It is unquestionably unconstitutional. And that idea that government can dictate how newspapers cover news has been tested right up to the US Supreme Court. And in every case, the media has been the victor, in every case. This bill asserts that media outlets in Maine fail to provide thorough editorial attention to criminal and civil cases. It requires mandatory follow-up stories and mandates that mugshots be removed if the accused is acquitted. Newspapers in Maine already follow cases. We publish follow-up stories. We have processes in place to consider requests to remove mugshots. LD 923 is the product of a bill mill and uses language replicated in multiple other states across the country at the urging of Special Forces of Liberty, an organization that conceals its origins and supporters. And everywhere that this has been introduced, it has failed based entirely on its unconstitutional directives. In Rhode Island, the bill was withdrawn by its sponsor. It died in Mississippi, Montana, and New Hampshire. Each soundly rejected it. But no matter its roots, this bill attacks the First Amendment, which guarantees without hesitancy that Congress shall make no law abridging the freedom of speech. It also attacks Maine's Constitution, which in Article 1 makes clear that no laws shall be passed regulating or restraining the freedom of the press. Responsible news organizations adhere to ethical standards that promote responsible journalism, and members of MPA follow the Society of Professional Journalists Code of Ethics, which says, in part, ethical journalism strives to ensure the free exchange of information that is accurate, fair, and thorough. An ethical journalist acts with integrity. Additionally, news organizations have practices in place to respond to community concerns, as evidenced by the evolution of editorial practices. And it is precept in news organizations to follow individual cases through to completion, from entries to police blotters to outcomes in court proceedings. The New England First Amendment Coalition has also submitted testimony in opposition to this bill, although it does not show up in the portal just yet. And that testimony is 2 pages full of case law and statutory references that show and demonstrate that this idea has been tested time and again and is proved to be unconstitutional in every case. When asked about this bill, the policy director at the ACLU of Maine said that government should never be telling journalists how to do their jobs. Accountability for ethical and responsible journalism must come from a dialogue between journalists and the communities they cover. It cannot come from a coercive and unconstitutional government mandate. This bill is indefensible, and we ask you to reject this move against a free press. Thank you, and I'm happy to answer any questions.
Thank you very much, Ms. Meyer. Thank you for your testimony before the Judiciary Committee today. Are there questions from committee members for Ms. Meyer? And I must admit, I was distracted in a chat on the folks testifying, so I don't know whose hand up was first, whose hand was up first. I'm going to call on Representative Evangelos.
Excuse me. Thank you, Mr. Chair. My hand was up first. If it wasn't, I'd admit it and defer.
Thank you, Representative.
Ms. Meyer, thank you. You've already answered my first question. Congress shall make no law abridging the freedom of the press, and that came into my mind immediately. But in a hypothetical situation, you know, taking into account some of the testimony we've heard, if a newspaper has acted with malice or irresponsibly, there is a remedy through the courts, right? I mean, newspapers do get sued, right?
They do get sued, but I will tell you that is a very, very rare event in Maine.
But there is a remedy through the courts, and the newspapers aren't, besides their First Amendment rights, if they cross the line and libel or slander somebody, there is a remedy, and you're not protected by any immunity around that, are you?
We are not protected. You're correct.
Thank you.
Thank you, Representative Evangelos. Representative Thorne.
Thank you, Mr. Chair. And I guess my question is procedural. If this bill is unquestionably unconstitutional, why are we going through this public hearing? And why is this bill even present if it's been deemed to be unquestionably unconstitutional? Because we wouldn't pass any laws or suggest bills that weren't constitutional. Am I correct in that? At some point, somebody would, in the revisor's office, would determine that it was unconstitutional and wouldn't allow it to go forward?
All bills, I assume this is a question to the chair, and I will try to respond to it, Representative. All bills requested by legislators to be printed, is my understanding, are printed. The revisor's office is not in a position to say this is unconstitutional. We are not going to print it. That might come out in an analyst's review of the legislation if there are constitutionality issues raised in a public hearing or in a work session, but I certainly would not want a legislator's right to introduce legislation to be thwarted at the first step. What you're hearing is testimony from some people who are presenting today that believe this statute, if enacted, would be ruled unconstitutional.
Okay, and a follow-up, if I may?
Is this another question to the chair or a question to the witness that just testified?
Oh, well, it may be. She seems to be very up on Constitution, so she may be able to answer it. If not, I would appreciate it if you did, because the parallel that I draw is between the First Amendment and the Second Amendment. And this one pertains to the First Amendment that says government may not pass any law restricting or mandating. And yet the Second Amendment says the right to bear arms, that right shall not be infringed. But yet we do have laws that infringe upon the right to bear arms. So I didn't know if this may be a parallel where in certain cases that right may be infringed upon with laws that are deemed to be at the benefit of society. Would that be a parallel I could draw?
I think we're getting a little off point, but let me just respond that if we have laws in effect in the state of Maine that violate the Constitution of the state of Maine or the Constitution of the United States, they would be so challenged, and it would be up to the courts to rule on them.
Okay.
To rule on that
Thank you.
challenge.
I appreciate your clarity and help on that. Thank you.
Thank you. Are there additional questions for Ms. Meyer? Seeing none, and I just want to make sure I didn't miss any real hands, because I know some people don't have access to the electronic hand, and seeing none, thank you very much, Ms. Meyer, for presenting your testimony today. We appreciate your time and attention. Thank you.
Thank you very much.
The next person that I have, next and last person that I have signed up to testify is also testifying in opposition to LD 923, and that is Michael Kebeda. Mr. Kebeda, as soon as you are ready to testify, I will remind you, although you know very well, we have a 3-minute clock, so proceed when you're comfortable, sir.
Thank you, Representative Harnett, Senator Carney, and members of the committee. Good afternoon. My name is Michael Kebeda, and I'm Policy Counsel for the ACLU of Maine. I am here to oppose this bill because it would threaten to erode our core constitutional freedoms. Free speech is the heart of our democracy. And for this reason, the First Amendment creates a wide berth for the press and their associated speech. The ACLU of Maine, like the sponsor of this bill, also recognizes the importance of people's presumption of innocence and how media exposure of people who have not received a sentence in a court of law may dramatically alter their image in the public eye. For example, reporters and political demagogues rushed to convict the Central Park Five in the court of public opinion, though it turned out that they were not guilty and that their convictions had been obtained through coerced testimony by the police. Unfortunately, this bill runs antithetical to the fundamental principles of our democracy, which include protection of the integrity of the press. There are already well-established laws in place that prohibit defamation, but those laws are the exception to the general principle that in a democracy, the people are the ultimate arbiters of the truth or value of information about matters of public concern, and not the courts. We can all do a better job of educating ourselves and our children to be critical consumers of news media, and we can and should demand that reporters uphold the high standards of their profession. As the United States Supreme Court recognized in 1964, one of the things that unites us as a people is our profound national commitment to the principle that debate on public issues should be uninhibited, robust, and wide open. We urge you to vote ought not to pass, and Finally, I'd like to turn the committee's attention to LD 563, where we were on the other side of the Maine Press Association, where we and a group of very diverse stakeholders found a better solution to the very problem that this bill seeks to solve. Happy to go into the details of that bill in question and answers. Thank you for listening, and thank you for your attention.
Thank you very much, Mr. Kebeda, but we will focus our attention today on LD 923, the bill that's in front of the committee. But thank you for your time, as always. Are there questions from committee members for Mr. Kebeda? I'm just going to check for real and virtual hands. And I do not see any. Thank you very much for your time and testimony. I didn't see you, Representative Libby. I apologize. I don't know if your camera was off for a second, but you may proceed.
Sorry about that. I have kiddos making their lunch in the kitchen, so I keep my
What are they
camera
having? Something good?
Annie's mac and cheese. Can't beat it.
That's good.
Thank you, Mr. Chair. Thank you for being here, Mr. Kebede. Another point regarding the freedom of the press is that in it not being absolute, is that defamation in kind, invasion of privacy, casting someone in a false light are not forms of protected speech. So what would your thoughts be surrounding that issue with regards to this bill?
That's a great question, Representative Libby. Unfortunately, when rights exist, only those well-heeled enough, only those wealthy enough to enforce those rights, to get those rights recognized in court, enjoy those rights. And most of the people that it sounds like Representative Sampson wants to protect with this bill are low income. And so even if that person has been cast in a false light, even if that person has been defamed through news reporting about their active court case, in the overwhelming majority of cases, that person cannot get a court to protect that right for them. And so this bill, in my view, even if passed, even if it was found to be constitutional, which we don't think it would be, would probably not serve to protect the rights that Representative Sampson wants to protect with this bill. Because the people who are generally speaking accused of crimes don't have the resources or the time or the money or the status or the privilege to enforce their rights in court. And so probably a better way, absolutely, probably a better way of protecting those rights is to restrict the kinds of information courts can share with the public and the kinds of information the state can share with the public about who's been accused of what crime.
Thank you, Representative Libby. Thank you for your response, Mr. Kebeda. Are there additional questions for Mr. Kebeda? Seeing none, again, thank you very much for your time today. The committee greatly appreciates it. I would now, those are all of the persons that I had registered to testify on LD 923, although I do see a question from Representative Hagan.
Thank you, Mr. Chair. That last question piqued my interest. I'm wondering if I could ask for the presence of Christopher Sevier to come in, and I'd like to ask him one more question if I could.
Yes, you may.
Thank you.
I would ask the committee clerk to move Mr. Sevier back as a panelist. Proceed, Representative Hagan.
Thank you very much. I don't see Mr. Sevier.
He's there, trust me.
Okay. So another, the question that was just asked piqued my attention. So I thought I was quick enough to be able to type this one. Another point that the freedom of the press is not absolute. Defamation in kind, invasion of privacy, casting someone in a false light are not forms of protected speech. I was curious as to your thoughts on that. Very same question that was asked to the last person.
Yeah, that's exactly right. I mean, like the parallel of the Second Amendment's not absolute either. Freedom of the press is very important. It's very important that we protect that, but it is not absolute. This bill is really important to one of the things that the lady who testified in opposition said is that this bill will require all mugshots to be taken down, all reporting on all cases, but that's not the case. This bill concerns when it gives power to individual who's the subject of news stories, where the media is profiteering off of that individual. If that individual wants the media to do a complete story on what happened, on the outcome, and if they qualify for it, if a person's accused of a felony and they get convicted of it, they can't enforce the statute. But if they're exonerated, if they're acquitted, if they're pled out to nothing, they can go back to the media and that individual, this bill gives power to the individual constituents who've been accused of stuff to go back to him and say, I'm demanding that you not engage in selective reporting in a matter that involves me being accused of wrongdoing before a government body. And so in that case, for the state legislature to require that the media outlet and that narrow circumstance to do a full, follow-up publication so the full story is out there is not unconstitutional. That would definitely, defamation in kind, invasion of privacy, putting someone in a false light. Those are not forms of protected speech. And you guys have a compelling governmental interest to protect your citizens from being bullied and abused. I mean, the media outlets are profiteering off of this, off of their reporting anyway. And as the other opposition said, she said that we're not sued very often. And so, yeah, I mean, in the instant case here, there's not going to be a lot of lawsuits. They might do the follow-up publication on their own, but if it's maliciously brought, if it's clearly a political hit job, if it's abusive process, if someone is getting off topic, right? If they're engaging what's called the ends justify the means practice, which happens all the time, then this will protect that individual. So I hope that answers the question.
It does. Thank you very much. Appreciate it. Thank you, Mr. Chair.
Thank you, Representative Hagan. Representative Thorne, is this an additional question for the witness who is being called back a second time?
Yes, Mr. Chair.
Okay, you may proceed.
Thank you. I just wanted to thank you for appearing today, Mr. Sevier, and providing your testimony and taking time out of your day to help us with this. We appreciate it.
Yes, Representative. Glad to do it. Just trying to provide, lawyers know just enough to be dangerous on any topic. But when you litigate First Amendment issues, and we do multiple federal district courts around the country, we have some insights. These matters are complex. They're not simplistic. Yeah, I would respectfully submit that, we see eye to eye with the ACLU on many topics, but there's a lot of times we disagree. Our motivation is not for donations. It's not for credit. We don't care about any of that. We just want to promote human flourishing. We're just thinking about your constituents, and we're just trying to provide you guys with some ammo so you can, if you vote in favor of the bill, you can understand that it is constitutional and it will work, and you will enable human flourishing. And at the end of the day, it's going to really help the media outlets because because there's no accountability on them, they've really eroded their integrity and trustworthiness by engaging in these kind of tactics. It's pretty clear that they do that. And it's really harming the quality of the profession. So the best thing that can happen for media outlets is for this bill to be enacted. And thank you so much for taking up this matter that's not simplistic.
Yeah, if I may ask follow-up, Mr. Chair?
One more follow-up, and then we're about to close the hearing, sir. But go ahead.
Is there a time limit that I'm missing?
You may proceed with your follow-up question, Representative Thorne.
Thank you. I appreciate that, Mr. Chair. Mr. Sevier, do you see any way that this bill would harm a media outlet by its requirement or be detrimental?
I don't really think so. I mean, the only thing I can think about would be, if they might feel inconvenienced with having to do a follow-up reporting. Maybe there's a tornado going on at the time during the 10-day threshold where they got to do a follow-up reporting, and they'd prefer to cover this other thing. But if they decide to cover a case in controversy, which they have the right to do, and if that person is then exonerated or acquitted, then because they're profiteering off of that person's misery or misfortune, having been wrongfully accused, if you will, then they even if they feel like it's a little bit inconvenient, they should be required to do this follow-up publication. I think it's going to help them because it's going to make prosecutors and media outlets think twice before they cover a case in controversy. If it's clearly a political hit job, then they would be less likely to cover it. But if they do decide to cover something and the person is exonerated or acquitted, and that individual does take the necessary steps to enforce the statute, then yes, they should be required to do it, but follow up with this. But I don't think it will hurt them furthermore, because I think it's going to promote truth and reporting. And I think the press needs to be known for not advancing fictitious narratives for some kind of purpose that they personally believe in, but just neutrally putting the facts out there. It's very important to safeguard the integrity of our democracy and justice systems, government systems in general.
Thank you for that. Thank you, Mr. Chair, for allowing me that question.
You're very welcome, Representative Thorne, and thank you, Mr. Sevier. At this point, I will ask again if there are any persons in the attendee room who wish to testify in opposition to LD 923 to indicate. Seeing no one, I would ask if there are any attendees who wish to testify neither for nor against LD 923 to so indicate by raising their electronic hand. Seeing none, having heard and received testimony from those present today, I now close the public hearing on LD 923.